These are the strict protocols for navigating power of attorney in West Bengal. For decades, real estate transactions relied on a specific loophole. Parties used irrevocable general powers of attorney paired with unregistered sale agreements to bypass ad valorem stamp duty and formal registration fees. This practice stripped millions in revenue from the state and created a vast off-book market of shadow ownership, resulting in broken chains of title and endless litigation. That decades-old system of relying on off-book documents to secretly transfer property rights is now entirely obsolete. The catalyst for this destruction came in 2011. The Supreme Court delivered the Sewerage Lamp ruling, establishing a unified standard for property transfers across India. This doctrine is clear. Complete legal title can only pass via a formally registered conveyance deed under the Transfer of Property Act. A power of attorney is strictly an agency tool, not an instrument of transfer. Any attempt to use a power of attorney to bypass formal transfer introduces catastrophic risk. Drafting a power of attorney in West Bengal now triggers an immediate algorithmic audit. The state uses the literal text of these documents to actively identify tax evasion and non-compliance. In this jurisdiction, a power of attorney is no longer a simple delegation of agency. It is a heavily regulated fiscal instrument. To secure property rights, we must map exactly how delegated authority is captured, taxed, and enforced. Ignorance of West Bengal's e-Nathikaran ecosystem guarantees administrative rejection and severe financial penalties. This structure illustrates the four foundational statutory pillars governing agency dynamics in West Bengal. Under the third pillar, the Registration Act, public registration is mandatory to secure legal efficacy. Section 49 dictates that an unregistered power of attorney for property worth more than 100 rupees cannot be received as evidence. It cannot affect the property in any legal capacity. This brings us to a persistent trap, the misuse of domestic notarization. For a resident Indian, a power of attorney executed only before a notary public is void for property registration. It must be executed before the jurisdictional sub-registrar. Shortcuts in authentication render any subsequent sale deed voidable by the original landowner. NRIs have a valid international pathway, allowing for execution overseas before a consul or foreign notary. However, the countdown begins the exact moment the document lands in Indian territory. Agents have a strict 90-day window. It must be presented to the collector for adjudication. Missing this window renders the power of attorney legally inadmissible. Geographic distance does not excuse compliance. It merely starts a rigid procedural clock. The Revenue Department categorizes delegated authority with precision. Each category carries a distinct tax burden. For developers' agreements under Article 48G, West Bengal captures revenue through a structured slab-based duty. But developers can reduce this cost. If full stamp duty is paid on the primary agreement, the associated power of attorney duty drops to a nominal 50 rupees. The most dangerous fiscal trap occurs when a power of attorney is given for consideration. If an agent pays to acquire property rights, the state pierces the agency veil. The document is treated as a de facto conveyance. This triggers full conveyance rates, up to 7% in stamp duty plus a 1% registration fee. Relying on boilerplate templates shifts the tax burden from a nominal fee to millions of rupees. The state has replaced manual, subjective property valuations with an automated digital baseline. This transition to a centralized digital ecosystem is designed specifically to eliminate undervaluation. During the e-requisition phase, the system uses an algorithm to generate a binding market value and a unique query number. The e-Nathikaran portal actively assesses the document's literal text line by line to ensure strict compliance with these automated rates. Under Section 47A, any mismatch between your stated consideration and the automated circle rate triggers a Form 2 notice and a formal collector's assessment. This process creates suo motu liability, leaving assessments open for a 5-year retrospective audit. Practitioners are no longer debating with human logic. They are submitting to an automated tax trap. Survival in this system begins with dismantling the misconception of the irrevocable power of attorney. Under Section 202 of the Contract Act, coupling a power of attorney with an unregistered agreement offers zero protection against bad faith revocation. Extreme drafting precision is required. Powers must be surgically codified to survive the literal text assessment of the e-Nathikaran algorithm. Furthermore, strict mandates now require the masking of Aadhaar and raw biometric data on all public-facing annexures to prevent administrative rejection. Transactional success depends on aligning strategies with West Bengal's digitized reality before the first draft is written. To succeed in modern West Bengal real estate, instruments must be surgically drafted, accurately valued, and immune to algorithmic title disputes.